In fact,
Mr. O'Neill, how long was the Sentencing Commission, how long did it consider this?
I believe that this was over about a 6-month period.
Okay. And I understand your point about, well, the commission, before it's going to make something retroactive, has certain hoops to go through. I get that point, and I appreciate that. But retroactive application of federal law also has some hoops to go through, and they're usually, we think of Congress doing those. And the evidence we have here is 403B that says it shall apply, tells us exactly when it applies, depending cases. Okay.
Welcome back to 45th Perspective. Today we're breaking down a Senate hearing that sparked a lot of discussion, a lot of misunderstanding, and a whole lot of strong reactions across the political spectrum. This hearing dives into how Congress handles retroactivity in federal sentencing, specifically whether certain sentencing reforms should apply to people who were already convicted before those reforms were enacted. And even if that sounds like a technical, legal topic, trust me, it has real consequences in the lives of thousands of Americans. Before we get into the details, if you're new here, make sure you hit the like button, subscribe to the channel, and turn on notifications. And if you want to support the work we do here, deep dives, research, breakdowns, and thoughtful political analysis, you can join us on Patreon at patreon.com/45thperspective for as low as $5 a month. It helps the channel stay independent and keeps videos like this possible. Now let's get into it. The Senate hearing in question centered around a specific section of federal law, Section 403 of the First Step Act, and whether Congress intended for certain sentencing reforms to be applied retroactively. On one side, some argued that Congress spoke clearly and deliberately about when and how these reforms should apply. On the other side, advocates and legal experts pushed back, claiming that the law left room for interpretation, especially when it comes to fairness, proportionality, and the practical impacts on people who've already been sentenced. During the hearing, you could feel the tension, not in a hostile way, but in the sense that both sides genuinely believed they were standing on the correct reading of the law.
Where no sentence has yet been imposed. And then with respect to retroactivity, it tells us it shall also apply to those drug offenses in 404B. That seems like Congress thought pretty hard about this, to Justice Kavanaugh's point. And it is a bit of a leap to say, oh, Congress didn't think about this. And retroactivity of a criminal law in a sentence, it just failed to consider it. It seems a plausible possibility, but perhaps a little disrespectful.
No, Justice Gorsuch, the question that Congress was considering in 403 was applicability to everybody. So does it apply to everybody moving forward, and does it apply to everybody moving back? Retroactivity would have meant that every defendant who had committed an offense before the act would have
pretty clearly ruled out, right?
We agree that is ruled out.
Okay.
Mr. Carter, because he is not in that class, he cannot claim relief under Section 403A. But Congress said nothing about whether the impact of those changes could be considered in the context of entirely separate.
I understand that, and so we're having to draw an inference. But boy, Congress spoke pretty clearly to retroactivity in 403 and 404.
So, Justice Gorsuch, I make 2 points. First, even the government agrees that these changes actually can be taken into account, even for defendants serving final sentences. So the government agrees that when you get to what it calls the sentencing determining phase in this 2-part stage that it imagines, that the court can take into account how the 403 changes affect the calculus. So that blows a hole in their idea that that Congress never wanted these changes to have any effect on final sentences.
Justice Gorsuch, for example, emphasized that Congress didn't exactly leave this ambiguous. And he wasn't wrong. There are specific sections that outline when the law applies. But the counterargument came from Mr. O'Neill, who made a point that Congress didn't explicitly forbid courts from considering these reforms in later phases of sentencing, especially in cases where someone is already serving time and facing a resentencing or sentence modification. This sparked a really interesting exchange. On one hand, you have judges and lawmakers who feel bound by the letter of the law, what Congress said, in black and white. On the other hand, you have defense attorneys, advocates, and even some members of the Senate saying, yes, but the spirit of the law matters too. And that spirit, in their view, was about correcting injustices in sentencing practices that were widely acknowledged to be excessive or outdated. This is where the hearing becomes more than just legal language. It becomes a debate about justice, fairness, and the evolving understanding of what a reasonable sentence looks like in today's legal landscape. Let's break down the core disagreement. It comes down to whether Congress intended for courts to look backward, not necessarily to wipe the slate clean for everyone convicted before the reforms, but to allow judges to take those reforms into account when someone returns to court for a new sentencing phase. And this isn't as unusual as it sounds. In criminal law, sentencing isn't always a one-and-done situation. People return to court for resentencing for all kinds of reasons. Errors in the original trial, changes in how guidelines are interpreted, new evidence, or constitutional issues. What became clear during the hearing is that Congress made their retroactivity decision explicit in some sections of the law but not in others. Section 404, for example, deals with certain drug offenses and clearly states when retroactivity does and doesn't apply. Section 403, in contrast, specifies that the new rules apply only to cases where sentencing had not yet occurred. But what Congress didn't do was close the door on courts using the new reforms as part of future sentencing decisions. And that is exactly the gray area this hearing tried to explore. One moment that stood out was the discussion around whether it's disrespectful to claim Congress simply forgot to address retroactivity thoroughly. Justice Gorsuch suggested that Congress thought about it in detail, and therefore it would be an overreach to interpret silence as permission for courts to apply reforms retroactively. That's a fair point. Congress often uses very specific wording when it wants to limit a law's reach. But Mr. O'Neill responded by emphasizing that Congress's primary concern was who gets the benefit of the reform automatically, without needing any further judicial involvement. And since Congress clearly restricted that group, the implication was that courts should still have discretion in later proceedings, especially when principles like fairness and proportionality are at stake. What's interesting here is that even the government's own lawyers admitted something important, that judges can consider these changes during what they called the sentencing determination phase of a resentencing. If that's true, then the argument that Congress wanted no effect whatsoever on final sentences becomes harder to sustain. This is where the politics come in. Sentencing reform is always politically charged because it ties into larger conversations about mass incarceration, the drug war, economic inequality, racial disparities, and public safety. Some lawmakers approach the issue from a tough-on-crime perspective, emphasizing consistency, deterrence, and the need to respect the original intent of Congress. Others push for reform because the data shows that mandatory minimums and stacking charges have led to excessively long prison terms that don't necessarily improve public safety. So when we watch a hearing like this, we're not just watching a debate about legal phrasing. We're watching two different visions of justice clash in real time. One vision says, if Congress wanted people already serving sentences to benefit from the reform, they would have written it explicitly. Since they didn't, the courts should not assume they meant to allow it. The other vision says, Congress wanted to correct injustices. And when people come back to court for resentencing, the judge should be allowed to consider the new law because justice should not depend on outdated rules. Both sides have valid arguments, and that's part of what makes this conversation so important. It shows how complex lawmaking can be and how the consequences of legislation don't always end when the bill is signed. What does all this mean for the average American watching from home? It means that the laws Congress writes and how they write them have long-lasting effects on real people. There's a difference between passing a law and fully implementing it. And there's an even bigger difference between implementation and fairness. Many families across the country have loved ones serving sentences that were handed down under harsh older guidelines. Even when reforms pass, it can take years for those reforms to reach the people most affected. One of the broader implications of this hearing is that Congress may need to be clearer in future legislation. If the goal is to change sentencing practices moving forward but not backward, that should be stated plainly. If the goal is to give judges greater flexibility in resentencing decisions, that should be clearly outlined too. Ambiguity creates confusion, and confusion creates inconsistent outcomes across different courts. Another implication is the growing recognition that sentencing, especially in drug-related cases, needs continual reassessment. Society evolves. Our understanding of harm, risk, addiction, and rehabilitation evolves. Even within the justice system, opinions shift as new data, studies, and outcomes emerge. The First Step Act itself was an acknowledgement that some of our sentencing practices were too extreme and needed adjustment. But as this hearing shows, the work isn't finished. Reform is an ongoing process. It's also worth noting that different senators approached the issue from different angles. Some focused strictly on the text of the law. Others focused on the human impact. Some questioned whether expanding judicial discretion could lead to leniency that undermines deterrence. Others argued that refusing to consider modern standards during resentencing is itself a form of injustice. And when you look at the bigger political climate, you start to see how sentencing reform becomes a kind of litmus test. It reflects how each party views the criminal justice system, what values they prioritize, and how they believe fairness should be balanced against public safety. The truth is, no single hearing is going to settle these debates. But they do give us insight into how the system works, and how complicated it can be to translate public sentiment into lasting legal change. What stood out to me personally was the way each side genuinely believed they were defending the integrity of the justice system. One side thinks fidelity to the text ensures fairness and predictability. The other side thinks flexibility and modern standards are essential for justice to evolve. And honestly, both perspectives have merit. A justice system that is too rigid can become blind to reality. A system that is too flexible can become unpredictable. As viewers, we don't have to pick a side immediately. We can listen, learn, and decide which arguments align with our values and our understanding of fairness. Another layer of this hearing deals with the relationship between Congress and the courts. Congress writes the laws. The courts interpret them. But sometimes Congress leaves gaps, intentionally or not, and the courts have to decide what to do with those gaps. That's where disagreements like this arise. Should courts interpret silence as exclusion? Or should they interpret silence as an opening for judicial discretion? Different judges will answer that question differently. And because of that, people's lives can be impacted differently depending on which judge they stand before. That is why clarity in legislation matters so much. For ordinary Americans, the takeaway is that sentencing reform is not as simple as passing a new law. It requires coordination, clarity, and sometimes even follow-up legislation to address gaps and interpretation issues. It also requires ongoing oversight, which is exactly what hearings like this are meant to provide. I also think it's important to acknowledge that many families are watching this hearing and waiting for answers. They want to know whether their loved ones will get a fair chance at resentencing. They want to know whether the reforms that Congress celebrated publicly will actually apply to the people they affect personally. These hearings might seem technical, but they carry immense emotional weight. So where do we go from here? The hearing didn't resolve the issue entirely, but it did highlight the need for Congress to clarify its intentions. Lawmakers may need to come back and either expand retroactivity, restrict it more explicitly, or outline the exact conditions under which judges can consider reforms during resentencing. My own opinion is this: if Congress believes that certain sentencing practices were unjust or excessive, then those same concerns should apply when someone returns to court for a resentencing. I don't think every reform should automatically apply retroactively. That can create chaos and uncertainty, but I do believe judges should have the ability to consider modern standards when making new sentencing decisions. Otherwise, we risk perpetuating injustices that Congress itself has acknowledged. At the same time, I understand the argument for stability in the law. Sentencing shouldn't be a moving target. Judges, prosecutors, and defendants need clarity. The challenge is finding a balance between consistency and compassion. One thing the hearing made clear is that the First Step Act was, in many ways, just that, a first step. It opened the door to reform but left a lot of work unfinished. If lawmakers want the justice system to be more proportional, more fair, and more modern, they will need to continue refining these laws. And that's why discussions like this matter. Not because they generate headlines or political soundbites, but because they help shape the future direction of federal sentencing policy. I hope breaking down this hearing helped you understand the stakes and complexity behind what might seem like a dry legal debate. These issues are deeply connected to how we think about justice, accountability, and fairness in America. If you found this breakdown helpful, make sure to like the video and subscribe to 45th Perspective. We tackle the news, we unpack the political context, and we aim to bring clarity to issues that affect everyday people. And if you want to support the channel and keep videos like this going, you can join us on Patreon at patreon.com/45th Perspective for as low as $5 a month. As always, I'd love to hear what you think. Do you believe sentencing reforms should apply during resentencing? Do you think Congress was clear enough? Do you agree more with the textual approach or the fairness-based approach? Drop your thoughts respectfully in the comments. I read as many as I can, and I appreciate the conversation this community brings. Thanks for watching, and I'll see you in the next video.